Good morning. My name is Scott Bischoff, and I'm with Adams and Bischoff Law Firm here in Charleston and proudly represent Mullins McLeod in his pending disorderly conduct charge. This morning, my office has filed a motion to dismiss the case against Mr. McLeod for a number of reasons, but primarily based on the clear, unlawful arrest of Mr. McLeod on May 14th, 2025, while walking in downtown Charleston without any indication whatsoever of the narrative that was put forward by the city of Charleston Police Department shortly after his arrest, that he was somehow acting disorderly. He simply was not, and the facts prove it. Body-worn camera footage from the officers that were involved that night, as well as the incident report itself, prove that a false narrative was put out in the very beginning regarding Mr. McLeod's conduct that simply has no basis in law whatsoever. We have asked the city to dismiss the case on account of the clear facts on the body-worn camera footage, but they have refused. And so we've been forced today to file this 21-page motion to dismiss on account of numerous constitutional violations, numerous violations of CPD policy. We have asked the city to conduct an internal affairs investigation regarding the officers that were involved in this case on account of over a dozen violations, all that go right to the heart of Mr. McLeod's and all of our God-given rights to be free from unlawful government intrusion. The night that Mr. McLeod was arrested, he was walking down the High Battery here in Charleston and doing nothing to call undue attention to himself. There was nothing about his conduct that interfered with the lawful enjoyment of the public space by anybody else. Nobody was around. These three officers took it upon themselves to approach him in a way and immediately arrest him without asking any questions. From the moment that they are within arm's reach of Mr. McLeod, they put him under arrest, they take away his freedom, and then they perpetuate this false narrative that the entire thing was based upon him somehow being disorderly or, as the incident report suggests, failing to identify. That is something that is going to be discussed at length in my motion to dismiss. Failure to identify in South Carolina is not a crime, but that is what law enforcement officers on scene, what's proven by the video, that's what they believe was a justifiable basis to take Mr. McLeod's freedom that night and then take him to the Charleston County Detention Center. Mr. McLeod, contrary to what's in the incident report, contrary to the narrative that was put out, gave his name twice, even spelling it to the officers prior to being put in the patrol car. So within seconds of being detained, he's giving them his name, he's spelling it, and they know his name. The body-worn camera footage that was never released shows that they call him by his name. They say, "Mr. McLeod, how do you spell your name?" They say his name over and over again to the point where it's absurd to believe that they did not know his name or that somehow he ought to be arrested as a John Doe because he failed to identify himself. The narrative that he was somehow walking along the High Battery in his boxers, likewise, has no basis in fact. The officers search Mr. McLeod upon taking him into custody. They search his pockets. Everyone knows underwear does not have pockets. It's absurd. But what they did and what we believe was done that night is they violated his rights in a way that ought not to be accepted by anyone, but certainly not someone who has done as much for this city and this state as Mr. McLeod has. We hope that the city will now, in light of the motion to dismiss the case. We hope that alternatively the court will dismiss the case in a way that is acceptable to the constitutional rights that we all have to be free of any unlawful government intrusion.